So the Maples case, which is being argued in the Supreme Court tomorrow, has focused an attention on two areas of pro bono practice that we thought would be worth reviewing. They are areas that involve relatively straightforward ethical issues, and the rules and obligations, which you should research in your jurisdiction because they vary, are fairly clear and straightforward. The devil is in the details, and the challenge here is in the execution, and we thought we could share with you some best practices. So what happens to cases when the pro bono attorneys leave the firm, and what are some best practices there? Well, one best practice is to get a hold and control of your docket now, not waiting for people to come and go. So do an inventory, take stock, see if cases where there haven't been activity in a while are really capable of being closed out and should be closed out. But sometimes cases, like death penalty cases, linger for many years and go on for quite a while without any activity. And that doesn't mean that they are capable of being disposed of, they just are sometimes a zombie case where there's a period of time without any activity and then they percolate back to life. So you could do some triage now and weed out the cases that are really capable of being closed, and that will make it easier to stay on top of all the cases at your firm that need attention. Another thing that pro bono responsible staff can be doing is reaching out and contacting the risk management professionals, their law firm general counsel, and their HR staff, and coordinate up front to make sure that pro bono is part of the exit process. So when an attorney announces his or her departure from the firm, pro bono is part of the to-dos and the checklists that go on with that attorney's exit strategy. So when they are preparing a list of matters that need to be restaffed, their pro bono cases are part of the list. When they're doing their exit interviews, part of the things that they're talking about are the pro bono matters that they are working on. And I think that firms have gotten much smarter and much better about coordinating with HR as we've seen tumult and more and rapid departures due to the economic crisis. And I think one of the lessons learned from that has been to tighten up your exit procedures. Another thing that pro bono staff can do is work closely with the assignment and staffing professionals to make sure that you are placing cases with people with whom it makes sense to place new cases. And if they have reason to know, for one reason or another, that an attorney is likely not to be at the firm for much longer, it may not make sense to place a new pro bono matter with that firm. And often the assignment and staffing professionals know this information. And it's not that you would need to breach confidential personal information, but there may be some tips and pointers that can help you all work together to ease any future transitions and to minimize surprise. One other area that I think would help with attorney departures is in the area of supervision. So they clearly go hand in hand. If pro bono matters are tightly supervised by partners and senior staff, they are likely to be staying at the firm and would know that the matter is active and needs additional staffing. So there could be some seamless transitioning there. Attorneys have the duty to supervise, so partners and people with expertise are responsible, and just as they do with their commercial cases, cases should be staffed in a way that people have competency and expertise. And pro bono can be fantastic training vehicles, but we're not learning on the job in a way that gives second-class justice to our pro bono clients. A lot of the issues in how we heighten partner supervision and how we get more partners involved in pro bono are larger than we can talk about here. It may involve a culture shift at your firm. It may involve assessing policies that may be a barrier to greater partner involvement. But there are a few nuggets that directly relate to supervision that I think we can cover now. Thinking about what are the barriers to active supervision, and does heightening and tightening your supervision necessarily mean a diminution of pro bono work at the firm, right? Because if you're going to clamp down, does that mean that you can take on fewer matters? Not necessarily. So you can still take on and have a lively and vigorous and effective pro bono docket while you are delivering high quality pro bono services. The two are not mutually exclusive and they can go hand in hand. So what are some areas or barriers that cause resistance and may impede active and more increased partner supervision in pro bono matters? It may relate to expertise, right? Partners may be reluctant to supervise pro bono cases because they're outside their areas of expertise. They do not regularly practice poverty law, right? They are not experts in landlord-tenant. They are not experts in child custody. They're not experts in asylum law, and do not feel like they have the competency to supervise in this area. So it may just be easier for them to say, no thank you, I don't want to get involved, rather than taking the time to learn a new area of law. They may be asked to supervise areas that they just have no interest in. Landlord, tenant, and housing law is just not a passion for me. Or they may not have the time, right? We're all so busy and they just feel like they don't want to bite off more than they can chew. And I think if you do some diagnostics and figure out what the barriers are, you can match up solutions to each of the problems. A few areas that I think firms have had remarkable success in expanding both the numbers of partners that they're able to get supervised and the effectiveness of that supervision, that it's meaningful supervision, is to think beyond the normal relationship of one-on-one supervision. I think when we think about supervising a subordinate, you think, okay, you've got one associate working on a pro bono case, you're going to find one partner to supervise them, and that's the model. If you think in terms of other models that you could develop, you may be able to enhance your active and meaningful supervision. So by that, what you may do is think about creating pro bono practice groups. So you may take an area where the firm has developed some expertise and has some interest, like asylum, like landlord-tenant issues, and instead of only working on a one-to-one model, create a practice group, just like you do with your paying work. And through this practice group, you've developed expertise, you've developed a center of excellence, and it may be easier for partners to supervise in an area where they already have either done the work themselves or who have supervised others. They've climbed a certain learning curve, so that's already appealing. And in a practice group setting, I think you feel like the time barrier may fall away because if you're not necessarily available to answer the questions, the other partners who have developed expertise in this area are there for people to ask questions to as well. So there's a redundancy built in that benefits the whole pro bono practice because you're not reliant on only one person. And that can lead to better work, better outcomes, and a more sophisticated pro bono practice that could be quite appealing. Think about using associates and senior associates. They've done work in a certain area, again, asylum, landlord-tenant, Social Security, disability benefits, whatever it is. They can supervise the people more junior to them who are now doing the work. And by having some built-in expertise, fantastic. You're not reinventing the wheel each time you take on a new pro bono matter. You're leveraging your expertise to get better results. You're also giving now that mid-level and senior associate a chance to supervise. So they are getting some core competency professional development skills that they need, project management, supervisory skills that they may not otherwise be getting. So you are leveraging professional development opportunities all along the continuum and the spectrum, and you're deepening your bench of potential active supervisors. In many communities, you can find mentors to help develop your expertise. So it may be the public interest organizations and legal services providers. It may also be unusual suspects. So in many communities, there are solo and small practitioners, small office practitioners, who this is their bread and butter practice, right? They are in landlord-tenant court all the time. This is what they know. They can be a tremendous resource. And in many jurisdictions, they are fantastic mentors to the pro bono bar. So work to cultivate non-traditional mentors who can help train, who can help you develop the expertise that you need to be effective supervisors. Think outside the box. Think about leveraging other firm initiatives to garner additional supervision opportunities. If firms are moving towards different evaluation and feedback systems as part of new talent management trends, as part of additional core competency trainings, the need to give meaningful feedback and evaluations can definitely be linked to pro bono matters and heightened supervision that requires to give meaningful evaluation and feedback. So these are just a few ways to think outside the box and increase your active supervision and lead to better and more high quality outcomes for our pro bono clients, and that these ethical obligations that we have don't need to be obstacles or barriers to pro bono service. And if we spend time, which we at the Pro Bono Institute do all the time, thinking about best practices and ways to, without unduly burden both our institutions and our lawyers, we can figure out best practices and meaningful ways on the ground to affirmatively do great high quality pro bono work that minimizes the risk to our institutions.